100%. You should tell your people no spyware, don't hack into a device, that kind of thing. If they've changed their password, don't guess their password and log in. Subpoenas to cell phone providers for the actual text messages are going to get you nowhere. They're going to say we don't have them, or they're going to give you a day's worth. There's also a federal law which allows them to deny it unless it's a criminal case. AI is good in a lot of ways. It's bad in a lot of ways, is that you can fake almost anything. Deep fakes, audio, video, it's kind of scary. And it's getting easier and easier to do. So you just want to make things sure as much as you can to prove things to the court is authentic and true.
Welcome, and thank you for joining us for another Justia webinar. My name is Mina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Kellum T. Parks. Kellum T. Parks is a managing member of Parks Ziegler PLC, headquartered in Virginia Beach, which is a paperless, technologically driven law practice with 3 offices across Virginia and North Carolina. He obtained his BA in philosophy with honors summa cum laude from St. Andrews University in North Carolina and earned his JD from the Marshall Wythe College of Law at William & Mary. Kellum is a Tidewater native and has been practicing there for 25 years. The webinar that you're about to watch will be approximately 1 hour, and once that's complete, Kellum will be taking questions from the audience. So if you have any questions that come up, please feel free to submit them by clicking into the Q&A button in the control panel at the bottom of your screen and sending them in there. We will go ahead and take those questions once the presentation is wrapped up. Now, without further ado, here is Kellum to discuss family law and digital evidence, preserving, presenting, and persuading.
Okay, welcome. So as Nina so kindly introduced me, my name's Kellum Parks. I've been practicing law for about 25 years. I've done family law for most of that. I do mostly cybersecurity, data privacy work now, though I do still handle some high asset divorces. I often teach and write on the subject of electronic evidence and other technology type subjects. And so that's what we're going to be talking about today. We're going to be talking about ESI, or electronically stored information, in the context of family law. Now, since this is a national CLE, we will be talking about, make sure my clicker works. We're going to be talking about the civil rules of procedure, which are going to be federal. I'm going to use the federal rules as a jumping off point because obviously every state's a little different. We're going to talk about how to get informed to be educated, preservation of ESI, discovery of ESI, so discovery tools within your case, and then how to use issues, that kind of thing, of ESI at the trial level itself. So before we get started, one thing I'll say is because you guys have the participants are going to have this have the PowerPoint and not a sort of a formal outline. I'm breaking cardinal rule number 1 of PowerPoint presentations, and you're just going to have walls and walls of text. I realize it's a bit ugly, but I wanted you, when I do CLEs, and I do a lot of these, what I want the education seminar to be able to provide a reference guide. I don't want you to have bullet points that you may not remember what it was if you didn't take notes or had to use the restroom. So I want this to be a guide that you can go back and use sort of as a jumping off point for your actual day-to-day practice. And so these slides hopefully will be able to give you that ability to do so. So what is ESI, right? So ESI is any electronically stored information. It often contains important information for a family law case, particularly, and relevant rules to understand. So again, we're going to go in the federal rules of civil procedure, understanding that family law cases are state laws, but every state has a little bit of a different take. Federal rules give you a good guide because they're generally the same for most states. So of course, you're going to have to look at your own state rules as we go through. So what is ESI? Well, it's documents, spreadsheets, images, instant messaging files, social media accounts, emails, basically anything that's electronic. As we get more and more digital, that's more and more things. I think I'm a big user of AI, generative AI at our firm and personally, and for my businesses, I own a couple. And one of the things that Sam Altman, who runs OpenAI, which is the maker of ChatGPT, said, hey, you guys might want to understand that it's discoverable. So you may not want to put legal research directly into ChatGPT if you don't have a paid account or have some sort of anonymized data in there. That's another area of potential ESI. So where do we find it? Computer desktops, external hard drives, flash drives, cloud servers. Most things are kept on the cloud these days. So if you have a practice management system, if you're using OneDrive, if you're using SharePoint, if you're using Google Drive, Amazon Drive, those are all cloud server type things. Smartphones, tablets, digital notebooks, if you use Remarkable, phones, recording devices, AI devices such as Plod. These are sort of voice capturing devices. Again, it's everywhere, and it may be very relevant to your case. So again, this is the first wall of text. I realize it's a lot, but I'm going to be sort of go through it systematically for you. So rules of discovery. So rule 26 on the federal rules, discovery doesn't need to be admissible. So rule number one is you're allowed to discover things that may not be admissible at trial. That's not the standard. 26F3, that's your conference and planning. That's much more relevant. And again, I practice in Virginia. We have lawyers licensed in North Carolina. So in my state, we don't do a lot of conference plannings ahead of time. So there's a uniform schedule in order that in most cases in the circuit court level, which is where divorce is, if we're doing custody, those types of things, we have what's called a juvenile domestic relations court matter. Some cities like Virginia Beach, where our main office is headquartered and where I'm sitting today, they have a scheduling order because they want to be more organized. Most JDR courts don't. But your state obviously is going to have different levels of court and different procedures. But in federal court, they have they almost always have a very robust conference and planning. And the plan must state the parties' proposals on the issues about disclosure, discovery, and preservation of ESI, including, move my window, sorry, including the forms if the parties agree on a procedure to assert, etc. So this is where you can really lay it out at the beginning if there's going to be any major issues. Discovery scope and limits, which is 26B in the federal rules. It says basically you can discover any non-privileged matter that's relevant to a claim or defense and proportional to the needs of the case, considering importance of the issue, the amount of controversy, relative access, resources, importance of discovery, etc. Proportionality is big in the federal rules. Again, different states are going to have different rules. I'm going to say that a lot. Virginia, we don't get into proportionality that much. It's obviously a very practical concern that the court's going to take into account, but it's not as explicit in the rules that that's sort of the ground rules that we're going to be getting into. 26D under the federal rules, discovery and timing. It allows you to deliver early discovery requests for production 21 days after service. You don't have to wait. That can impact ESI planning. Again, we don't have that in Virginia, but other states might have that. So as always, I always say go back to the rules, understand what you have the ability to do and not do as you plan out your case. Then we're going to be talking some strategic considerations moving forward too when you talk about effort. What I like to say is the juice worth the squeeze. Okay. So next we're going to talk about Rule 33, which is interrogatories under the federal rules. You have the option to produce business records. So Rule 33D in the federal rules says that if the answer to interrogatory may be determined by examining, auditing, compiling, etc., or summarizing business records, including ESI, and if the burden of deriving or ascertaining that will be substantially the same for either party, then as a responding party, you may answer by specifying that they must be reviewed in sufficient detail. And again, you can give them the opportunity to come in and look at it. So when you have a divorce, which is usually where we're talking about this kind of stuff, obviously a party isn't necessarily going to have business records. But if you do high asset divorces like I do, the parties are owners or have a lot of different business interests, or they own real estate, or they have other interests in some sort of business. And so a lot of times we are going to third-party businesses to try to get information and determine what's going on. So this is where this certainly would come in with that option to produce business records. So Rule 34 under the federal rules is producing documents, ESI, tangible things. So request for production of documents, generally what we call. And all these rules, again, wall of text talks about that you may serve a request to produce to inspect these kinds of things. So you can go there and inspect it, or you can request them to provide it to you. 34B1C says that you may specify the forms or form in which ESI is to be produced. So this is important because if, for instance, let's say that the husband or the wife in this case are owners or somehow they're affiliated with an engineering firm, you may, for some reason, you may need to look at plans. And so you don't want them to send you CAD documents because CAD, or files, I should say, they're proprietary format, and you may not have the ability to open them or read them. So you can say, hey, I need these in a PDF format, or I need these in this certain kind of format that you're able to view. Doesn't do any good if you get the information in a format that you have no ability to access. Uh, it also states under these rules that a party may state it will produce copies instead of inspection. They may state an objection to the requested form. If the objection is made, or if there's no form, then the responding party must state that it intends to use. And then it goes on to say that unless otherwise stipulated or order, that they must produce as they're kept in the usual course of business and organized. So an electronic format, back when I started practicing and we did large cases, and I've handled civil litigation cases across business, torts, federal, all sorts of different kinds of law, as well as family. When you have a big case, a lot of times they'd be like, hey, here's a warehouse full of documents, or here's 500,000 boxes, have fun. With ESI, because it's so easy to organize, the courts really don't let you just mismatch it, because almost always it is organized in some format. All right. So this is the getting informed and educated part. Before starting, you need to consider some basic things as you're planning out your case. A common mistake is not properly identifying how ESI is stored, both with your clients as well as third parties that you want to get them. You need to consider the type of evidence. Are there going to be, and again, in family law, a lot of times when you're dealing with the individuals, you have family computers, you have tablets, you have cell phones, you have computers. If it's business, you might have photocopiers. Photocopiers sometimes nowadays have a lot of electronic evidence stored in them. Email accounts, social media accounts, all these things you have to think about. Where would the information be that I'm interested in getting? And then you have to start think about how to get them. A pro tip is get IT professionals involved if it's a lot. Again, for my high asset divorces, we do this sometimes where we have to access cell phones, for instance. They've deleted things, or we need to get all the information. I'll hire an expert to get the items. If it's a business, we might have to do some e-discovery tools, figure out what's going on if there's a lot of data. Again, you have to kind of figure out the scope of your case so you can determine what makes sense from a cost and effort perspective. One of the things that I provided in the materials is an example of a good checklist. So the U.S. District Court for the Northern District, California, they created a checklist for their 26F meeting, which is the meet and confer under the federal rules regarding ESI. And that's a good place to start about thinking about how to handle ESI in general. So even though it's a federal case for civil and doesn't have anything to do with divorce, if you go to that link, it's a very good checklist to sort of how should I be thinking about ESI? What are some of the things I should be considering when I'm planning out my case? And if you do a lot of these and you really need to get into it, what I consider sort of one of the Bibles of this stuff is a book called E-Discovery Digital Evidence, and it's written by a guy named Jay Grinig. He updates it every year, and you can buy it. I think it might be Royer Thompson, people on Westlaw. I think that the book's under them as a publisher, but if you go and just Google it, you can find him. And that's a great book. It gives you forms. It has electronic, digital things you can use for orders. Again, if you do enough of these, it makes sense to perhaps go into that as a resource. So another thing is when you're thinking about it, so think about preservation letters. You should send what we do here at my firm, and we've got 13 lawyers, about 8 of us do family law across Virginia and North Carolina. We send litigation hold letters. So that's something that I have found that a lot of family law lawyers don't think to do. And again, if it's a very low level divorce, you probably don't need to do this. But my partner and I and some of my other partners, we handle high asset divorces, and we don't want things to get lost, destroyed, or otherwise be unavailable to us. So we send out, we have a standard litigation hold letter that we send out at the beginning of every case. Craig Ball, who's been around a long time, a well-known trial lawyer, he's a certified computer forensics examiner. He has a comprehensive preservation guide on his website. I've given you the link here. The one that I used to link was back in the 90s. He updated it back in 2020, which is nice. And if you go there, you'll see he's got this litigation hold letter that goes on for miles. It's way more than you're probably going to need, but it's a great place to start because you can always pare it down, and I'm positive you're not going to miss anything. For instance, if I'm doing one for a company, ours is, I think, 7 or 8 pages long. If I'm doing one just to an individual, it's a lot shorter because I don't need to talk about a lot of the stuff that companies have. As you're going through this, you need to ensure your individual client, and of course, a company maybe that they own or that there's some relationship with where you expect maybe the other side might be trying to get information from. You have to understand that you need to make sure that your client and these third parties understand their obligations if they get a litigation hold letter. And I've underlined this, that it includes communicating the hold letter to every person affected. You have a duty to preserve relevant ESI, which is determined by finding key players. Again, this is in sort of a company setting. The Zubalake case is a great case. I think it's actually the Southern District of New York. I have Northern here. I think it might be Southern. But if you do the citation, it'll come up. Even though it's a 2003 case, it was one of the first cases, and it's very, very detailed on this kind of preservation type language, which is great. But you need also to follow up with your client, these third parties, to ensure that it's continually be followed. So what I have found in the past for some of my cases is, well, they hold the stuff and then they stop holding the stuff. They're not deleting emails. They haven't segregated it. Things are starting to continue to be produced. And then when the time comes for discovery production, oh, we didn't keep that. And that can cause some real issues. We'll talk about spoliation in a little bit. So you don't want that to happen. So let's talk about discovery in general. So it may be, and this seems a lot, and I understand, but it may be necessary to propound discovery about how information is stored before you actually issue discovery about getting the information. Why would that be? Well, if you issue discovery and to say, hey, I want the stuff, you might get too much or you might get too little because you didn't understand the scope of what may exist or what formats they have, or certainly what formats they have or what they need, how long it's going to take. Or they can go, hey, we're going to give it to you. It's going to cost $600,000 to produce. Probably not worth it unless you have a very high asset divorce. So you really want to make sure you understand the scope of things. Again, if it's just two people getting divorced, nobody owns a business, then it's pretty simple. Phones, tablets, computers, that kind of stuff. Every case is different. You just need to be strategic about it as you get into it. You need to consider the format desired of the ESI produced, right? Native format or some other methodology. I gave the example of CAD documents versus PDFs, that kind of thing. Deliberations must be made regarding strategy considerations being overly inclusive. Overly conclusive versus specific. For example, a broad request could be objected to for being overly broad or unduly burdensome, whereas specific requests as to the location of specific media can avoid them. But then if you're too specific, maybe you miss something. Unfortunately, I can't give you a black and white idea there. You just really have to consider, hey, what is out there? What things should I consider? And this is where I'll give a plug for AI. So anybody that's not using AI, I recommend you should. So go get a $20 a month paid for ChatGPT, for instance. That's the one I mainly use. I could talk for days about AI, but AI can really help you in this case. And you're like, hey, this is what my case is about. Again, you don't have to give client data. This is what my case is about. These are the kind of things I'm worried about. And this is the kind of environment I think it is. What should I ask? And it would spit out for you, hey, you really need to think about this device. Have you thought about this? And you can do a back and forth to sort of tease out creatively what things you may be missing because you don't have any experience with it or you just didn't think about it. The goals, budget, time, and venue are all important consideration when crafting ESI discovery to ensure each request is best tailored. A lot of cases I've had, it's at the end of the day, I'm like, look, there's probably really good information we can get, but it's going to cost you $20,000 for us to get it because I have to hire this expert or I have to do this when I work. And sometimes it's just not worth it from a cost perspective. So things to include in discovery request, a complete listing of all sources of ESI. So that's a discovery. You can say, hey, give me every electronic device you use and give me a list. Identification of all people responsible for maintaining hardware, software, retention, and destruction policies. Again, this is company related, but oftentimes there are companies involved. Again, consider strategy being overly inclusive versus specific. If it's broad, it could be objected to. Specific requests could be missed them. So it's the same thing that I've said before. These are things you just need to consider. Okay, social media, right? Everybody's favorite as a family law attorney. Used to be not such a thing, and now it's obviously people live their lives online. So I'm not going to go into what these, I think everybody knows what these are, but you have Facebook, Instagram, X, formerly Twitter, Snapchat, YouTube is a big one now, Reddit, obviously, TikTok, and Reddit, actually, I have on here 2.9 million. I looked at it the other day. I think it's up to 3.3 million. You'd be surprised what people put on the Reddit. But there's lots of places where social media is online, and these are just the well-known. You have Instagram. There's a million, right? WhatsApp. But there's a ton. So there's a lot of places online where people are sharing information. So discovery, sort of in the context of social media requests, as in state court, relevancy is the threshold of issue of discoverability. The federal rules of evidence permit a party to obtain discovery regarding any non-privileged matter that's relevant to a claim or defense that's proportional to the needs of the case. Again, I went into this proportionality issue. Federal Rule of Evidence 401 establishes that evidence is relevant if it has a tendency to make a fact more or less probable than it would be without the evidence, and the fact of a consequence in determining the action. Therefore, private social media is discoverable. It has a tendency to make a fact, either related to the claim or defense, more or less probable and is of consequence. Unlike state court, and I say there could be states that have proportionality, Virginia really doesn't, it's very emphasized to reduce extraneous, albeit relevant evidence. I like that particular thing in federal court. They're used to very large cases, and that's why they came up with these rules. Courts are instructed to consider the importance, how much it's going to cost, all that sort of stuff. Again, even in Virginia, even though we don't really have this distinct proportionality in our rules, the judges do that, right? They're like, hey, this seems pretty excessive. Tell me why I should allow you to do this. And you have to back it up. Again, your state may have broader or more restrictive rules. For interrogatories in particular, an interrogatory you might issue is identify all social media accounts, including deactivated accounts, and provide the log information, including username and password. I'll get to objections in a minute. It enables the party requesting unrestricted access to that and metadata. Spoiler, almost always objected to. In Virginia, at least, I've never seen a judge allow this unfettered access to social media accounts. But another more sort of tailored question would be identify all usernames, screen names, handles, or other pseudonyms used by you in connection with any social media platform. Specify which platform each name is associated. I use this one regularly in our stock discovery because I want to know what I don't know. Maybe I don't know all your social media accounts. And it also is a way to catch them in a lie because a lot of people, unfortunately, don't tell the truth. And if they're signing an interrogatory under oath, these are my social media, and you happen to find one later, or you happen to know some that they didn't list, it's a good way to destroy their credibility and help you in your case overall. Request for reduction. Again, you could say produce the entire content of your entire social media account. Facebook and Snapchat have an option where you can download everything on there, instructions. I've seen this discovery question. I can't tell you I haven't issued it, and sometimes they do it, and sometimes they don't. I've had cases where I ask for their entire Facebook account. They give it to me. They ask for my client's entire Facebook account. I object as to overly broad. We go to court. The court says, well, they gave you theirs. And I'm like, well, they didn't object. And the judge usually smiles and says, well, that's right. And I do think it's overly broad, and you should have given it to Mr. Parks. So you have to understand your own court, your own case, but that's usually objectionable. Produce all communications you've had with the opposing party concerning the facts here, including messages, posts, and photos. That's something that I use oftentimes, and usually it's enough to survive an objection because it's tailored to the facts of the case. Produce all photographs shared germane to this litigation. I think that's vague, but you could make it more tailored to your particular case. Produce all Facebook, etc. posts relating to the facts alleged in the pleading. Again, that's pretty good. And if you really want to get specific, you can go into specific paragraphs if it's a divorce on your complaint or specific issues. Again, the more specific you get, the more likely you're not going to have an objection, or at least overcome an objection. Request for admission. If you have a social media post that you want to admit in order to avoid having to establish authenticity, have the other side acknowledge it and the genuineness of it in a request for admission. And I'll go into these a little more sooner, but request for admissions are your friend. In Virginia, we have a limit of 30 if it has to do with a fact. We have an unlimited amount for request for admissions as to authenticity of documents. So oftentimes, as I get close to trial, I will send out hundreds of requests for admissions about every document I want to get in regarding social media, emails, that kind of stuff, because I don't want to have to authenticate them. Objections. Requests for a private social media account are nearly always met by objection. Some of them are usually unnecessary invasion of privacy. I don't know what that means. We don't have a general right of privacy in Virginia, but they state it. Speculative fishing expedition. not really an objection, but I get it. Requests overly broad, unduly burdensome, won't lead to discovery of admissible evidence, and not relevant to issues of the lawsuit. So the last ones are sort of more proper objections, and may or may not be sustained. As I said before, requests for all social media, if not limited in time and scope, will likely be met by the objection that the request is overly broad. Objections may be to providing general visible content as well. So if it's an open, if you're asking for information that's out there, if it's an open Facebook account, which usually isn't the case anymore, but if it's a website or whatever, a lot of times they'll say, "Hey, it's available to them. We don't have to go through the effort of having to download and get that. It's open. They can go get it themselves." And that's in the most state rules. It says, "Hey, if you have the ability to do it yourself, the other party doesn't have to kill themselves." So to do it for you. So just understand that that may be an issue. You also might have, they may object to producing social media without a protective order. So that's one way you might be able to get around it. That's more oftentimes done with business sensitive information or whatever. But I've had that case where there's certain, say, risque pictures or photos or texts and embarrassing or whatever. And they say, "Hey, look, I don't disagree. It may be relevant, but we don't want this. We want this under a protective order." Oftentimes, I don't fight those at all because I'm not looking to try to smear the other side in the public. I'm just trying to get what I need to do to win my case. And so it just sort of depends on everything. In camera review, you can request to be produced to the judge to sort of figure this stuff out. Subpoena ducis tecum, so you may be able to obtain private social media through issued directly to social media platforms. I will tell you, good luck. Every platform has a mechanism in which you can send them. If you go online, you can figure those out. I will tell you, almost all of them are going to make you file in whatever state they are, and they're also going to probably fight it. I'm not saying you won't win, but it's going to be super expensive. I can't imagine in most divorces that it's going to be relevant unless it's super high asset divorces, but it's possible. So let's talk about spoliation. So first of all, we have an ethical obligation, and I'm going to give you the ABA rule, but ABA rule 3.4 says, hey, you have an ethical duty not to obstruct another party's access to evidence or unlawfully alter, destroy, or conceal it. So you have a duty to preserve this stuff. Spoliation encompasses conduct that is either negligent or intentional. And the comments say that it makes an offense to destroy it to impair. Falsifying evidence obviously is a criminal offense. And it talks about evidentiary applicable may take temporarily possession of physical evidence. And this is criminal, not civil. So you have an obligation not to destroy or obstruct evidence. So hopefully none of the attorneys watching this would ever do something like that. And we all know that sometimes our clients might do something stupid. And so you want to make sure that they don't do this as well. So we always have that talk at the very beginning. You want to review your appellate cases, federal cases for specific guidance. There's often a scarcity of state precedents concerning ESI in general. So that's where the rules of federal evidence and civil procedure really come into play because they've dealt with this for a long time. It's very detailed. They've spent a lot of time on it. It's usually best practices. And so what I have found, and Virginia has gotten better, so we have supplemented as early as 2019, I think. So maybe 6 years ago, they did some more amendments of our rules to really sort of beef up this ESI stuff. There's still a lot of gaps. And so oftentimes if I have to get into this fight, I'll go to court and I'll say, well, judge, Virginia law, here's the rule. It's kind of vague. There's no cases on it whatsoever, circuit court, trial court level, or appellate court level. There's nothing there. Hey, but it's very similar to the federal rules. And under the federal rules, here's a case that talks about it and it really goes through it. That's very persuasive to a trial judge that doesn't have any kind of precedent to go by, maybe be unfamiliar with it. I have the advantage of having done this for a long time. I'm the ESI guy. I'm the tech guy. I ran the Virginia State Bar's Special Committee on Technology and the Future Practice of Law. So when I go into our local courts and the other side doesn't really know what they're doing and the judge doesn't necessarily know, I've sort of got hey, I've been doing this a long time. Trust me, judge. And as we all know, that sometimes that's pretty persuasive. But I like to come in with proof. So I come in with the federal court cases. I come in with as much as I've got. One good resource for you to learn about some of the stuff and really the cutting edge stuff as it's starting to come out is the Sedona Conference. So it's a nonprofit legal policy research organization that has various work groups. They have judges, lawyers, experts, and they talk about privileged ESI, proportionality, all sorts of stuff. So I've given you a link here for their publications. So if this is something that you really have to deal with or you get into a lot, this is a great free resource to get into to really understand it. And again, if you can become an expert on this stuff, and I use expert in quotes, it really will not only will help your case, but it will also help sort of your credibility with the judge, and you can inform them, and they will tend to believe you a lot more than the other side just as out of habit, which is helpful. So one of the things that we have to worry about, especially in family law, and I'm sure anybody's done even a couple of divorces or custody cases has faced this. It's, well, what about the legality or civil liability of accessing devices? So I just recently, there was a local attorney that reached out and said, hey, I've got some questions about this. Can I pick your brain? And they had this issue that I faced many times, and that I had this issue, I think 6 to 8 months ago, where it was, well, they didn't lock we had a shared family computer and then they got into my records, or we separated, I never changed my password and they used that password to access my account, or it was a cloud backup and I didn't realize it was backed up onto the device, or I had the wrong iPad and it turns out it was the stepmom's iPad and I accessed it and I was able to find this juicy stuff. Can I use it? There's nuances to all of this. And so you need to make sure that your client's not committing a crime, which in Virginia, you can actually, even if they committed a crime and getting the information, you can produce the information. It's not necessarily per se inadmissible. However, they may go to jail afterwards. So you just want to make sure your client, you don't win the battle and lose the war. So criminal liability, you're going to have to look at your state law for this. I used Virginia's as an example. We have one under 18-152-4, which basically says it's unlawful for anybody with a malicious intent or through intentional deceptive means to use a computer or computer network to make or cause unauthorized copies in any form, including printed or electronic, etc. And if you violate it, it's a class 1 misdemeanor in Virginia, which is jail up to 12 months. There's also a federal act, so the Federal Stored Communications Act. Think of this as the Wiretapping Act. And this basically criminalizes, and there's also a civil cause of action for somebody that intentionally accesses electronic services, obtains, alters access. I gave you a case, Hatley v. Watts really talks about it pretty well. And the offense is if you intentionally access without authorization a facility through which electronic is provided or exceeds authorization. So this is sort of you're hacking into some device here. Punishment, again, it could be a felony. Definition of electronic communication service, that's one of the triggers here, is any service which provides to users the ability to send or receive wire or electronic communications. Emails have been recognized by courts as a form within this act. Well, what about electronic storage? Again, this is getting super technical. I've given you all the statutes you can really get into. But this is any temporary and immediate storage of a wire electronic communication incidental to the electronic transmission thereof. Courts have disagreed whether emails remaining on a server after delivery fall within this. So what I mean by this is if you have some sort of ability to intercept an email in transmission, you're definitely going to fall under this act. If, on the other hand, you've without authorization have accessed somebody's email, whether it be on their server or somebody's cloud server, the courts have disagreed whether they're not in 100% alignment on whether that would trigger this. But the most recent case law indicates that it would. So again, you just have, both from a federal and a state point of view, you had the details matter about how somebody got the information. There's also civil liability. I'm going to sort of, in the interest of time, I'm going to skip through these. They're in the materials. But at the end of the day, just understand that most states have a civil liability component. So in addition to potential criminal liability, you also have the lower evidentiary standard standard of proof for a civil, where you can sue somebody for doing this. And in Virginia, it's regardless of whether it was malicious intent. There's no definition of malicious intent under the statute. I give you a case that was Texas versus Piles, And this is he compromised a secure server room, disconnected components, access to financial server, changed the BIOS boot up. The jury awarded punitive damages, and the court determined the award demonstrates found malicious intent. So you don't have to have malicious intent to be liable, but you do have to have malicious intent to have punitives. So again, I want to stress, and this is something you should, as a practice tip, 100%, you should tell your people no spyware, don't hack into a device, that kind of thing. If they've changed their password, don't guess their password and log in. And if you get materials that's juicy and damaging to the other side, certainly ask. Don't be the blind, deaf, and dumb. The three monkeys to put your, see no evil, hear no evil, speak no evil. You need to ask. Hey, where did you get this? How did you get this? Because again, there could be, they don't understand. They don't know. Well, I had the password, or it's a fan. I had the device. I knew how to get in. May or may not be legal. So you just really want to make sure they don't get themselves in trouble, and that you don't accidentally get them in trouble by admitting something that you had no idea was illegally obtained. So let's talk about rules of evidence here. So we've talked about what is ESI, where do you find it, how do you get it in discovery, how do you fight producing it in discovery, making sure it's legal, preservation. We talked about all these things. So now we're at trial. So the idea is, or you're preparing for trial, the idea is, well, how do I get it into evidence, or how do I keep it out of evidence? And we're going to walk through some of this analysis. So first of all, first thing you need to think about is hearsay. And just for those that need a refresher, hearsay is a statement that the declarant does not make in the current trial or hearing, and the other party offers it to prove the truth of the matter. So anybody who's done any trial work understands it's an out-of-court statement for the truth of the matter. And it is not admissible unless the following provides otherwise. So a federal statute, these rules, or other rules by the Supreme Court, includes recognized exceptions, which we'll talk about some that particularly have to do with ESI in a few minutes. And the strongest rationale is there's no opportunity to cross-examine. So that's the kind of thing, is like, well, it's not fair to have the statement in here when I have no ability to question the validity of that statement. One thing you have to understand, there's a special context for ESI. Records generated exclusively by a computer systems or process, like a fax report, right? We're lawyers, we still do faxes. I don't know why, but a fax will show when sent and received. They're not made by a declarant, and that's part of what hearsay is. It should not be considered a statement, and there shouldn't be a hearsay. There may be obviously issues with proving authenticity, which is a separate thing. Hey, that's not even a real document. But as far as when it was sent or when it was received, that's not a hearsay argument, because again, that was produced by a machine. There's no declarant for these quote unquote statements. It's not even statements. They're factual items. So I'm going to be talking again about federal civil rules and federal evidentiary rules. You need to look at your state. But just because evidence is electronic doesn't alter the rules of hearsay. Hearsay is hearsay, generally not admissible. There are some exceptions, as I said a moment ago, that are more frequent with ESI. One is present sense impression, and that's a spontaneous statement describing or explaining an event or condition made contemporaneously with or while the declarant was perceiving the event or condition. Emotions run high in custody cases and divorces, and if they're going crazy in an electronic format, you might be able to get this one in. Same thing with exciting utterance, right? That's an impulsive statement prompted by a startling event or condition. The third one is existing mental, emotional, physical condition. So it talks about their mind, emotions, sensations, physical condition. And so it might be a text. Hey, I'm very angry, I'm very upset, or I'm distraught. Or if you're ever in a custody matter, might be a whole thing about whether the parent has in the right state of mind. So all of these issues, these are good exceptions. Hearsay gets complicated, but just because somebody says hearsay, don't give up, because it may not be hearsay, or it also might be an exception. Probably the biggest exception for hearsay is the business exception, the business records exception. And under this, basically, if a record was made at or near the time of the act by somebody with knowledge, it was made kept in the ordinary course of business, making or keeping it was the regular practice of that activity. All of them are shown by the testimony of the custodian of records or some other qualified witness. And neither of the source shows and indicate a lack of trustworthiness. So this is where we have, I've combined two in Virginia. So we have the business records affidavit. So when we do a subpoena ducis tecum to a third party company, we say, hey, here are the record, really a third party, but a company, particularly because of business records. We go, hey, have your custodian, here's what we're looking for. Have your custodian records fill this out. And they fill it out and say, hey, I'm the custodian records. These records were kept in the organizer's business. And we've listed out all the Virginia requirements. And the other thing that I pair with that is in Virginia, we have the ability to avoid an affidavit and you can have somebody just make a declaration. So we combine the two and we just have the custodian sign a declaration to say these facts. The custodian doesn't have to go find a notary, which oftentimes businesses might not have, and they can do a declaration and they're sending it back in the format I need. And now, hey, poof, now they're all hopefully admitted as business records. So I don't have to worry about that. There's also statements and agent documents under the federal rules. It's any document prepared before 1998, which makes me feel very old because that's 1 year before I started practicing law and I was an adult. So to say that I'm ancient is not welcomed, but that is what the rule says. Different states have different, I forgot what Virginia's year was. It's different than 1998, but so look at that as well. Also, you have admission of specific forms of ESI. So I'm going to talk about some of these specific things to walk through for you. Emails, texts, that kind of stuff to give you some pointers there. Must confront 3 hurdles: authentication, hearsay, which we've already discussed, best evidence rule, and there's sort of a fourth, which is usual relevance and probative versus prejudicial type things. I'm not going to talk about that because that's outside the scope of a sort of ESI, but obviously it's got to be relevant, right? And it can't be too inflammatory. Not really. I will say that probative versus prejudicial doesn't come up very often in these cases because we don't have juries for family law cases. So, and I'm not sure any state does, but Virginia doesn't. So that argument usually is for juries. The judge can make their own determination. So let's talk about the first one is sort of a authentication. Go back here. Yeah, okay. So requirement authentication of identification is a condition precedent. Certified records generated by electronic processor system. Specifically, Federal 902.13 has this that says that a record generated by an electronic processor system produces an accurate result by a qualified person that complies with the certification requirement. There's actually a certification. And that would be, for instance, proving a USB device was connected to a computer at a certain time, or proving that a server was used to connect to a website, or proving that a person wasn't in a location by using pictures or information from a phone. So this is where you can get around, this is where you can authenticate that information. There's also a separate one, which is subsection 14, which is certified data copied from electronic device. And this basically says, hey, if anything's copied and it's authenticated by a process of digital identification, again, by a certification, then you're okay. And that would be authenticate any kind of thing that was taken from a data force. So you send a cell phone to an expert to pull the data. They will ghost the phone, and then they will work on that ghosted copy, basically mirror image of the phone. They go through the data, they produce it in different formats, they use different tools, and they come back and go, this is what we found. And then they can authenticate that through this method. The proponent of evidence under these must also meet the notice requirements. There's a notice requirement under 11 to say this is what we're doing and here's how we're proving it. Best evidence rule, right? Original writing. This talks about that a writing consists of letters, words, numbers, or equivalent. An original means the writing or recording itself or any counterpart that if it accurately reflects the information. So it could be a printout or a copy, which is very important for ESI because normally you don't have the original stuff. Admissibility of other evidence of contents. Originals are not required. And if all originals are lost or been destroyed, again, and not in bad faith, this is a big deal for ESI. No original can be obtained by judicial process or procedure, absent bad faith. The original is in the control of the party against whom it's offered. That party is put on notice that would be proof of hearing, and they do not present it at a hearing, and the writing is not closely related to a controlling issue. So this is where you have lost data, and you're like, oh, here's a copy. Summaries. You can also use the summary chart calculations to prove the content of voluminous writings, recordings. That's not convenient. We do that all the time with a lot of documents. I had a high asset divorce where somebody had 4 years of bank records for a business that had a bazillion transactions. And we had spreadsheets and I had summary charts from the spreadsheets to go over the data, and I didn't have to produce the 95,000 documents. Opposing party had them all, but I didn't have to put them all in evidence, and the judge didn't want to look at them anyway. So you can do summaries. Authenticity. Let's talk about email, particularly here. This is what I'm talking about. So you have to authenticate the email. First step is to have the person who authored it testify that it's authentic. And so that's easy to do with your client, may not be easy to do with the other side or a third party. They may deny it. If it's not possible, then you can have circumstantial evidence, external facts verifying the identity, metadata. So you could basically, at the end of the day, you could have an expert testify that it is because they went on the computer and here are all the hallmarks. The Lorraine v. Markle American Insurance case has a really good discussion of this kind of stuff. So I recommend reading that to get a good scope. An example, you can obtain routing information from the email service, which shows IP addresses. What is my IPaddress.com? It's a website to look up IP addresses, and that may be a shortcut to help you a little bit. Evidence can be proven by comparison from experts or the trier of fact. Again, the Lorraine case really goes through that, which is good. Text messages. It's the same analysis for person of knowledge, circumstantial evidence, etc. Some practical tips, having done this a long time. Subpoenas to cell phone providers for the actual text messages are going to get you nowhere. They're going to say we don't have them, or they're going to give you a day's worth. There's also a federal law which allows them to deny it unless it's a criminal case. So you're probably not going to get the actual text messages from the provider themselves, but it's possible to retrieve them from the devices, because delete doesn't always mean delete, and oftentimes they don't delete them. So if it's the right case and if it's important enough, you can ask for the device in discovery. You get the device copied by the expert. The expert can go in and get it. There's plenty of great tools for your client to download their own. I think iAmazing is the one that we use here at the firm. It just basically you plug your client's thing into the computer pulls all the records off of it. Bam, you've got all the text messages, timestamps. It's perfect. So it's a really easy way to get it. Another practical tip that I actually encountered this issue was, you want to have the cell phone records to show if there was text messages sent at the time. So if you don't actually have the messages, you want to be able to prove maybe a call came in or not, because when you get the cell phone records, it will tell you if a text has been sent or received. It just doesn't give you the substance. Well, it's easy enough to change the address book name of a sender text. So this example is a case I had where a father changed the name of his girlfriend in his phone to be the name of the child's mother, my client. And then the girlfriend sent damning text pretending to be my client, the mother. Father takes screenshots off of his phone. This is 20 years ago, before you could actually pull text messages off cell phones. They literally took a picture. And he said, look, this is, and it didn't have the number on the top. It just had my client's name. And it was purported to be. Well, I actually had the cell phone records from both parties, and I was able to show that no text messages were sent or received at that time, which really helped, because, and we were in juvenile court where discovery was limited at the time. And had I known all that was coming, I obviously would have subpoenaed the girlfriend's records, but I managed to survive for another day, and the judge didn't believe it, which also helped my case, because the judge thought that the guy was a liar, because he was. So again, weird stuff happens. And today, as easy it is, AI is good in a lot of ways. It's bad in a lot of ways, is that you can fake almost anything. Deep fakes, audio, video. It's kind of scary. And it's getting easier and easier to do. So you just want to make things sure as much as you can to prove things to the court is authentic and true. Social media, same analysis, personal knowledge, circumstantial evidence, expert witnesses. You can additionally obtain information from the media provider. Like I said, it's very hard to do, but it's possible. And you also can do a forensics review of the device itself to get it, whether it's a computer, whether it's a cell phone. This stuff hangs out, right? Especially in computers. So you may be able to get this stuff. It's just costly. Voicemail, video, audios. So foundation can be shown by a witness who's familiar with the things and the sound. You don't have to be, and sometimes I found younger lawyers that don't know this, you don't have to have the person who left the voicemail say that is the voicemail I left. You can have somebody else go, oh yeah, that's his voice. I know it. They left it. Opinion about a voice. There's a federal rule 901B5, which says that an opinion identifying the person's voice, whether heard firsthand or whatever, You can do that. Telephone conversation, again, there's federal rules that sort of go to verify those things. Request for admissions. Bottom line is, and I don't want to run out of time, so I'm going to speed through here a little bit in case there's questions too. But for request for admissions, um, if somebody fails to admit the genuineness of a something and you have to go hire somebody to prove it and you win, the court must award attorney's fees unless it was objectionable, it's unconscionable. There's some outs. But bottom line is if you have to go through the hassle, you have a good argument to get attorney's fees. Practical tip, again, you want to make sure the other person admits these things and authentic. It'll just be easier for you. There could be discovery sanctions. So don't hide the ball. Don't let your client destroy evidence. Make sure that you show up to depositions and you answer things. Again, I put all this, as you can see from this wall of text, in great detail for you. And at the end of the day, if somebody doesn't do what they're supposed to do and you put them on notice, the federal court rules in Virginia modified their rules a number of years ago. It's presumed that you should get attorney's fees and costs. The question is how much. In Virginia, we're always frustrated because if I have to go to court, it's $5,000. It takes, expensive and it takes time. And the court goes, oh, I can't believe they didn't answer discovery. Absolutely, I'm going to sanction them. I'll give you $500. So then my client ends up having to pay anyway. So again, this is all litigation sort of practical stuff. There are, and the federal rules are very good about this. That's 37E. It's failure to preserve ESI. So when you do preservation letters, particularly, there's a whole list of rules about what happens if you haven't produced it. Failure to participate in a discovery plan. So in bad faith, if you haven't figured this stuff out, the judge, especially in federal court, will pop you. State courts may be different. All this information's in the slides for you guys. So last thing I'm going to say, sort of takeaways, and that way we have some time for some questions, is we live, it's an understatement to say we're in an ever increasingly digital world, right? So when I started practicing, it feels like a million years ago, 25 years ago, we had email, but we didn't have, there weren't the cell phones for all the pictures. Social media was still very infant stage. Computers were used, but they weren't crazy like they are today. There certainly wasn't AI. But now it's everywhere. Everybody lives online. They share their life online. And the good news is oftentimes you can find evidence to help prove whatever you need to prove. Bad news is there's just a lot there. And so you really have to be aware. We actually have in our retainer agreement, we tell people, hey, we really advise you staying off social media while you're in the divorce. Nobody ever does that. We say, hey, if you're not going to do that, at least be cognizant that this stuff may be discoverable. So don't be stupid. We're a little more, we phase that a little differently, but that's the idea is, look, don't be dumb. Like I always say, just imagine that a judge is on your shoulder at all times. You have no idea what the judge is going to be able to, what we're going to be able to discover in this. And I don't want to have to dig you out of a hole. It's important to know your state court treatment of ESI, know the federal rules to fill in those gaps, use discovery rules to your advantage, ensure the battle's worth the cost. And this is a big one. You will be sure to frustrate your client if they're stuck with a high bill for discovery battle that produced nothing of significance. You really have to be strategic about this because you don't want to spend all your money and be done. Hold on one second. My camera just switched. Okay, well, it turns apparently my camera just turned off, but I'm right at the end of the CLE. So I apologize, but I'm still here audible for the last 5 minutes to be able to provide any kind of context I can provide for you guys. Are there any questions? And then last contact, obviously, here's my contact information. My law firm's on the left. I have a coaching company on the right. If you go to the website, there's a free newsletter I send out every Tuesday talking about technology and AI. I'm happy to share that with you. But Nina, are there any questions about what I've provided?
Thanks, Kellum, and no worries about the camera. There are a couple questions coming through. We can now go ahead and move on to questions. As I mentioned at the top of the presentation, if you have any questions for Kellum, please feel free to put them in the Q&A button in the control panel at the bottom of your screen. So our first question is...
Yeah, Nina, and I see them. If you want, I'll just go straight through it and I'll save you the need to, I'll read them out though. So I've got somebody asked, are screenshots still considered reliable evidence or are there better alternatives? If we're talking about screenshots of text messages, they're still fine. It's just much easier for you to use something like iAmazing or some other third-party software. There's a couple of good ones out there. What I always say, by the way, when it's like, what's the best software? I used to say, just Google it. Now I use AI search. I like Perplexity, but ChatGPT and these others have search. They do a better job searching than even Google does. But bottom line is go search on the internet and just say, hey, best device to do X, Y, and Z. You'll see the reviews. And certainly you can ask people that use it. But whatever you use, it's just easier to use a device to download it because then you can actually have it sometimes in the native format. You can word search it. You can do all sorts of things. Screenshots sort of are old school. It's kind of like photocopying pictures. It's just harder to do, but it still works from an evidentiary standpoint. Next question I had was, and these are anonymous attendees, but the next anonymous two, maybe the same one. What tools or vendors do you recommend um, authenticating social media content? So the answer is find an expert. What I would recommend for cost purposes is find an expert that's close to you because you're going to have to pay them to do the work. We use, I don't have any affiliation with them, but Sensei Enterprises out of Northern Virginia is great. They do nationwide work. That's SENSEI Enterprises. I've used them for a long time, and they do a great job of all sorts of digital forensics. Again, what I would do is I would talk to the people that are I just realized I'm looking into a camera that's not on. That's hilarious. Okay, so I was like, why am I looking up? So there's lots of vendors. I would say at the end of the day, I'm always happy to give, and you can email me. I'm happy to give you some thoughts on it. But I talk to other people in your community that have used them and had good experiences because you want to make sure that they have a good reputation. You want to make sure their costs. You want to make sure that they'll show up and do the work. And also, one of the big things too is you have to make sure, if necessary, they're willing to come to court and they can testify well. I've made some mistakes early in my career, 20 some odd years ago, where maybe I hired a great expert who was the best in the field, but then when they got to court, they were horrible on the stand. And so all of these are sort of strategic decisions you need to make. Next question from another anonymous person is, what steps can I take to prevent inadvertent spoliation of digital data during discovery? So, um, the idea there is the one thing you can do is you can obviously take a snapshot sort of the account, and so you can hire an expert to sort of get the data so that somebody doesn't accidentally alter or delete it. That's a big one. And then just have conversations about it as well. It's like, hey, if this is something that's important, maybe don't use this account right now. Um, I've used experts to try to preserve that data. We take a snapshot of it. If it's moving forward, again, if you have a company, a lot of times their IT people can figure out how to do that and make sure, because it can get pretty technical. But that's where I always go to the IT professionals because even though I'm an IT geek, you might not be. A lot of people, a lot of my clients aren't. I've got to instruct my clients on how to send me an email sometimes, which drives me nuts. But it happens. Next question was, are there any jurisdictional differences in how digital evidence is treated in family court? Absolutely. So look, you know that I always say to my clients, well, if the rules are followed to the letter, we should win this case, but it also depends on which judge we have, and it depends on what side of the bed they woke up this morning. So it absolutely makes a difference on where you practice law, the level of court you have, the judge you're in front of that day. It's just so specific for family law cases, as all litigation, but even more so I found in family law cases. Our juvenile domestic relations court, which is the lower level of court where we go for modifications, custody visitation when you're not in a divorce, I find that they don't have a lot of patience for any of this stuff because they have so many cases. And so we've got 4 hours to try a custody trial. Good luck. So again, it's sort of that strategic information and you kind of have to figure that out. Um, let's see. How can I ensure, I did that one. I did that one. Um, how should I ensure digital evidence from a client's phone is properly preserved for trial? Again, that would be if you really need to maintain it in its format, then just you hire your own expert to ghost it. And they say, hey, this is the exact contents of the phone on this date and time. And that's just the easiest way to do it for sure. If you don't have that kind of money, you might even say, hey, go get another phone and just turn the phone off. And then that phone is as it is and nobody's used it since that time. That's the easy way to do it. Then they need another phone, but that's probably cheaper than an expert. How should I address concerns about manipulated or altered digital evidence from opposing counsel? Yeah, that's tough. I mean, if you can prove it, and again, that's where the expert witness comes into play. And if you think that the opposing counsel did it, now you've got ethical issues and report them to the bar. I fortunately haven't found that issue. Fortunately, we're a little more collegial down here. Not that we can't dust it up, but a lot of times what I find is that the clients lied to their attorney. And what frustrates me sometimes is the attorney not willing to sort of acknowledge that, but it happens. So you just really have to take care of it and then go to court and fight about it. Say, Judge, this isn't accurate and this isn't true. And you fight about it and you do a sanctions motion and you take it from there. What are the best practices for laying foundation when introducing digital evidence at trial? You just really walk through, and again, go back to the slides. That's why I provide that text heavy. I've violated every rule of presentation possible, including my camera dying, apparently. But for the actual, you just go through and you want to make sure you've authenticated it, that you've dealt with hearsay objections, that you've the best evidence rule. Just go understand the rules of your jurisdiction, walk through all the requirements well ahead of time, and that will help you issue your discovery as well as getting it into evidence or keeping it out of evidence if that's what you need. Can you review setting the foundation to ask a witness questions about social media posts? Sure. So if there's a social media post, you simply say, Ms. Smith, I have in front of you a Facebook post. Do you recognize this post? I do. Is this a true and accurate post that you made on Facebook on this? It has a date and time on it. Is this a true and accurate reflection of what you posted on that day and time? It is. Okay. That should be enough to get in there. True and is this a true and accurate copy? Does it maintain what was actually there? Again, the problem you have with opposing side is they might go, nope, which is why I always just do request for admissions when I've locked down my evidence. And I don't do it at the very beginning because I don't want the other side to know what my evidence is going to be. But when I get closer to trial, I do request for admissions and I go, admit the authenticity of these. And I've done hundreds of these documents. And I've also done sometimes where I'll put in 500 requests for admissions and I'm only going to use maybe 150 or 200. Again, I'm not purposely saying I'm not going to use the others, but I don't 100% know. But I don't want to be locked down at trial when they say, hey, I can't do this. Last question we have is, what ethical pitfalls should I avoid when accessing or collecting a spouse's digital information? Wow. That is an entire course. So the bottom line is go through your state's criminal and civil liability for computer trespass. That's usually the phrasing. Go through the Digital Stored Communications Act, which I provided to you in some case law there. You just have, and we have we basically just go through and go, okay, how did you get it? Did they have access? And there's nuances. Like we had one where they got separate, they owned a business together, then they separated, but days after they separated, the woman got in the hospital and the nurse gave the guy the phone, and the phone was her business phone, but he knew the access and he thought he had to do something in the business. And then there was a burner phone and it turned out that there was a paramour. And the question is like, well, they took pictures of these, or did they have ability to take access? Well, it was a password that wasn't changed. Well, they were separated. Should they have known? It gets very nuanced. And so it's not an easy question. It's a good question, but it's a factual step-by-step analysis that you really have to get into. Last one, because we're a little over time. Last one is, and this is long, but what do you suggest when a side does not deliver discovery or interrogatories? The judge is ordering assets to be sold, removing the wife and children from the home, again, without any kind of evidence of due process, rendering mother homeless. Opposing side gets the evidence thrown out. It goes on. Let's see. The home was sold. The judge. Okay. So very long question about what do you do when at the end of the day, they didn't provide discovery. In every case, if what I always do, and I just did it today, if the discovery is due on Monday and I don't have it, I send out a letter on Tuesday going, hey, I don't have mine. I'll give you another week, assuming I can wait a week. If I don't have it in a week, on the 8th day, I file a motion to compel and I set it for a hearing. And then we go and I have the hearing. And then the judge says, you need to order it by this date. If it's not by that date, I go back now for a motion for sanctions. And a lot of times in our court, in Virginia at least, I can ask for adverse inferences or maybe even win the case. Now, this is a very long question and had some very dire consequences for this attorney's clients. I can't tell you it's always worked, and I can't tell you I've been equally frustrated, but I just stay on it, and you just need to keep fighting and fighting and fighting, and hopefully you win. My biggest complaint is I never get all my attorney's fees. And I don't know why my client should have to pay a dime of attorney's fees when the other side hasn't done what they're supposed to do. It is what it is. I tell my clients from day one, litigation is expensive, and we just do the best we can. But I'm sure Justia, I think just you've sent them the slides, right? Okay, good.
That's correct. Yeah, all the slides are available for download.
Okay, and you guys have my email address. You can reach out to me anytime. I'm always happy to talk about this stuff or provide any other information I can. And like I said, every Tuesday I do a free newsletter in the morning to go out on topics of AI and technology and other stuff. So I'm happy to do that too. Just add you to the list. Just send me an ask.
Thank you so much, Callum, for all of those additional insights. Really appreciate you answering our audience questions. And thank you all so much for submitting your questions. We deeply appreciate your participation. We want to thank you all so much for joining us today for another Justia webinar. Before you go, don't forget that Justia Connect Pro gives you access to CLE credit opportunities through select live and on-demand webinars just like this one, helping you stay informed and compliant. You'll also get access to a myriad of other benefits, including an enhanced directory profile, AI-powered Justia chat to capture more leads, and exclusive discounts on other Justia marketing solutions. If you'd like to learn more, you can go to pro.justia.com. Thank you all so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.